Let me
Everyone.
know when we're good to go. Oh, I see it. Got it. Okay. So, as I said, what's happening is that I'm gonna I want to go through a little bit of a background sweep before I get to your work in academia and your work on access to justice and Indigenous communities. Just to talk a little bit about, who you are and how you came to be where you are right now. Because as we know, you've done work in, public sector, regulatory bodies, academia, and private practice. So I just wanted to go through a bit of a overall rewind of what you've done and how these jumps came to be, like how you managed that, and it's just simply what presented the opportunities to um, make your legal careers such multidimensional.
Oh, well, good question. I always love to talk about myself, especially at the beginning of an interview. The I guess as I said to you, or as we were sort of leading into this, one of the things that I was a fairly typical, for my generation anyway, law school graduate. I assumed I would go into private practice and do something interesting in private practice for the rest of my life. And I kind of started out on that direction, although in law school, I'd had some exposure to kind of public law and thought that was very interesting. And so I was in private practice for about 12 years in a suburb of Victoria. And I had done some work with Indigenous people, primarily in litigation. And the kind of issues fascinated me. And at the time, the BC government was just opening its doors to the treaty process, having historically denied Aboriginal title and denied any obligation to Indigenous people. And so I thought, well, that was really interesting. And they were looking for counsel on what was then called Aboriginal law issues, and in particular in the treaty process. So I decided to leave private practice and join the BC government to do that. And I did, and I thoroughly enjoyed that. It was a very kind of rich and kind of evolving area, relatively new at the time. And it became kind of a passion for me for a while. I became head of Aboriginal law, and then an opportunity opened up in the BC government to become Assistant Deputy Attorney General in charge of civil side legal services for BC. Fighting the imposter syndrome that I felt at the time, I put my name in and was appointed. And then, and I did that for 7 years. It was an absolutely fascinating job because of the variety of kind of civil law, civil litigation, and issues that presented themselves in a government setting on a daily basis. And then I got sort of tapped on the shoulder to move into deputy minister positions as Deputy Secretary to Cabinet in BC, Deputy Minister of Intergovernmental Relations, and Deputy Minister of Labor, all of which I enjoyed, each of which, of course, presented their own sets of challenges and huge opportunities to learn. I was sort of in that kind of space for about 4 or 5 years, and I started to feel like I really wanted to get back into what I saw as more justice sector focused work. And I saw an ad in the Globe and Mail for the CEO of the Law Society of Ontario, and thinking that they would hire somebody from Bay Street. I thought, well, it's safe to put in an application, and maybe my name would appear in somebody's contact list for future kinds of opportunities like that, because they were using, of course, a recruiter. Anyway, to make a long story short, they called me down for a couple of interviews and offered me the job. So I had to think very hard about whether I wanted to leave the pleasant confines of Victoria and Vancouver Island and move to Toronto, but I did. It was a great move. Loved Toronto, loved the work there. Wholly a different perspective on justice when you're dealing with it from the perspective of a legal services regulator. And then I moved on from that and decided to come back to BC, which was always the intent. And I just sort of got offered a faculty chair back at my alma mater, which is the University of Victoria, where I am right now, chair in law and public policy. And I'm cross-appointed to the Faculty of Law in the School of Public Administration, and teach access to justice and legal ethics in both faculties. So yeah, it was just a question of, I don't know, seeing opportunities when they arose sometimes, and sometimes, as I said, kind of fighting the urge to not change and to actually take advantage of making changes.
It's always hard to leave your comfort zone.
Yeah. Yeah.
Yeah, of course. I wanted to backtrack a little bit into what you said. You said there was an interesting change on the on your legal perspective when you went from the public sector into the Law Society of Ontario. Um, I wanted to touch a little bit on that and see what kind of legal change took place in your perspective.
Oh, I think it got me to start to think about, I'd always sort of taken lawyering for granted. I'd certainly taken the regulation of legal services for granted and not really thought about what it meant, like what the regulation of legal services, what the legal services monopoly meant, and in particular, what that meant in terms of access to justice and access to legal services. And so when I got to Ontario, people were thinking about that. I mean, this was, access to justice had by then become quite a serious issue, and the Law Society there was taking it seriously. And I did start to think about, what are we doing as a regulator, and is contemporary regulation of legal services really serving the public interest? So those are things I had not really encountered or thought about in government. I've certainly looked at regulatory issues in many other contexts, but not in the context of my own profession.
That's very interesting because you think while working in the public sector there would be an emphasis on there'd be a certain emphasis on access to justice in regards to the public, like a certain focus on the public interest. But as you're saying, I think I'm getting the fact that there was more of a focus on the public interest and the legal profession within your position of the Law Society of Ontario rather than your work in the public sector.
Yeah, I mean, it's not to say that there isn't an interest in and a desire to work on access to justice issues in the public sector, although I think I've seen that more recently than it was when I was there. But there was certainly a lot of kind of policy work being done on simplifying procedures and recognizing that people were not necessarily getting access, at least in sort of conventional terms, to courts and tribunals and decision makers in the way that they should. So that issue was out there, and there was certainly lots of work being done on it. I think it became more focused and more concentrated, and certainly more focused on the profession when I was in Ontario, because of course, government largely lets law societies regulate the profession. So, and it's more or less usually, unless there's something terrible happens, more or less usually quite happy to let lawyers kind of self-regulate and leave that to them. So it was there where I started to look at, well, and in concert with many, many other people, of course, the impact of what that meant for people who needed the access to legal services and access to having their issues resolved.
Okay, great. Did you get to work in the sort of issues that you deal now in academia while you were in the public sector?
Some of them, yes, some of them. There, some of the early work I did in the public sector around, Indigenous law and or looking at kind of how we could structure treaties and kind of look at different systems of law and different understandings and interpretation. We started to look at that then. I mean, the work's been much more developed in the last, say, 5 to 10 years than it was then, but we were certainly starting to look at that. I found that fascinating. Some of the other, certainly, as I said, there were access to justice issues and initiatives happening while I was there, and we were part of that. The division that I was looking at were part of that. And there was certainly an ongoing kind of efforts to build relationships with First Nations in BC that permeated a lot of public policy, no matter where I was.
Okay, great. I wanted to ask, so throughout the evidence development of Indigenous law that you experienced throughout your career, how did you come to look or to analyze the intersection between the legal profession and our court system and whatnot, and Indigenous claimants and Indigenous advocates? So like the very intersectionality of it. how did it come to affect or to play?
Yeah, and I mean, I don't want to oversell my own expertise in this area, right? I mean, I come at it, and I recognize, and I should say at the outset, I come at it with a particular positionality here as a, by and large, a relatively privileged white male. So I haven't lived a lot of these issues, and there are many scholars and academics and people working in the system that are probably better positioned to, or have a richer, deeper academic background in Indigenous law and in intersectionality. I respond to this question with a bit of humility and a bit of trepidation. But I can offer here the perspective of somebody that has been learning in this area and continues to be a learner in this area, and an observer. And I think that there's no question that our justice system was and is deeply colonial in origin and practice, and that it has perpetuated massive systemic racism, sexism, and violence, particularly in this case against Indigenous peoples. And we see that in many different ways. A very obvious example is the overrepresentation of Indigenous people in incarceration, and the rates are still trending even higher, despite, one would have thought, efforts that were being made to try to address that. The kind of Reclaiming Power and Place report on missing and murdered Indigenous women talks about the documentation of human rights organizations that take Canada to task for not addressing issues with respect to the intersectionality of issues with respect to Indigenous women and girls. The TRC, the Truth and Reconciliation calls to action, calling for equity for Aboriginal peoples, again, looking at that. And it's kind of ironic, I suppose, that we're talking today when we anticipate the federal government's response to the federal court's decision on the Human Rights Tribunal's compensation order for First Nations children and the recognized discrimination in the child welfare system. And the fact that, although I generously suspect that there is a desire to deal with it, our justice system so based on precedent and the fear of setting precedent that somehow we can't take that issue, which is deeply bound in intersectionality, and come to terms with it and deal with it, and deal with kind of the most vulnerable kind of members of our society in terms of Indigenous children. So I see Indigenous advocacy here for self-determination, saying that we can't really begin to kind of decolonize our system until we understand how the system perpetuates the interlocking structures of oppression in the lives of Indigenous peoples and communities. And that intersectionality needs to look at the ways in which, social categories of gender, race, ethnicity, ability, and class and Indigenous identity kind of reinforce each other. I think the access to justice movement, if I can call it that, and certainly this area, suffers in some respect from the failure to recognize that intersectionality or to profile that intersectionality, to try to address these as one-off issues. And they're not. And until we actually recognize that and kind of bring them together, we won't successfully move towards decolonization. There's some hope, I think, in what the courts are doing. I see recognition of intersectionality in some discrimination cases generally, and perhaps that's permeated, at least to some extent, litigation around Aboriginal or around Indigenous people. I'm thinking particularly here of Gladue and recognition there of the effects of colonization that Indigenous people face and continue to face. But there again, has that worked? The idea of Gladue, or at least part of the idea of Gladue, was to deal with some of the overrepresentation of Indigenous people in incarceration. And it hasn't, the stats are there, it has not dealt with that. And it certainly had a very mixed kind of practical application across Canada. So I think there's a lot of work to be done. I don't think it's just in the court system. I think there's an intersection between courts and government and public dialogue here. And I've gone on way too long.
No, not at all. From what you said, I wanted to ask, um, did you think did you think the notion of or principle of precedent or common law acts as an obstacle to the mentioned intersectionality or access to justice?
Yes, I do. I mean, I think it's important, and I don't want to necessarily diss it entirely, but I think our adherence to precedent and the fear of what we might be doing today impacting what we do tomorrow, or to look backwards, the sort of need to find something that was said elsewhere to justify what we do today, inhibits creativity and change in our system, and to a very significant extent. And I think it also it becomes a way of thinking, right? It becomes a way of thinking that we start to internalize in law school, and therefore, it really is something that we have to be very careful about. There's nothing wrong with it. It's served us well in many ways, but we can't be too slavish around it. And I feel that sometimes we are. There's got to be creative ways to work, and there are many creative lawyers out there dealing with it. Otherwise, we'd never advance the law. But I do feel it does inhibit us.
Okay. Well, as you mentioned, you are, to my understanding, you are one of those lawyers that deal with the sort of issues that we talk about here. So I wanted to ask.
Not sure everybody would agree with that, but thank you.
I wanted to simply ask, in terms of a personal opinion, what does access to justice mean to you and the work that you do and the work that you've done throughout different sectors of our legal system?
Thank you for that question. It's my conception of access to justice has evolved over time. I'm very much, as I said earlier, a learner in this world, in this environment. And I think my conception has evolved in common with a whole lot of people who sort of think about access to justice. And to me now, it's a very broad conception, and it means the ability of individuals, families, and communities to effectively address challenges in their lives and achieve a state of well-being. And that is a very wide lens to put on it, but that's very intentional. Because, historically, we used to think of it as access to court or access to legal services. So what do? You have a one-off solution, you put legal aid in, and then you complain when there isn't enough money, and there never is enough money for legal aid. And nothing wrong with that. There should be legal aid, and it should be well-funded. But it starts to focus us on very kind of one-off solutions. And access to justice is, in fact, a wicked problem. It is multidimensional from multiple sources, and we're going to have to look at it from multiple perspectives. To me, it means that usually the kinds of challenges to one's well-being do involve some kind of conflict or dispute or impediment to that well-being. And I'm borrowing heavily here from some work we're doing in BC. There's a coalition of 50 plus access to justice and justice sector organizations headed by the Chief Justice that are looking at access to justice issues. But, we're recognizing that you have to bring a holistic view to this definition, looking beyond kind of individual wins and losses to the needs of the people that are in the system, and to address kind of the whole person or the whole community or the whole family or the whole ecosystem even. Again, it's a system that it implies that there is a system here that's decolonized, learning and accepting, and other, and in particular here, Indigenous legal orders, and responsive to self-determination, and it's a system that drives inclusion and equity and cultural humility in its recognition of people's needs. And we've been talking a lot lately about legal capability, and a system that actually enhances people's legal capability, both by enhancing their ability to understand when they have an issue that may need a justice sector solution, or at least in part a justice sector solution, and then providing them with agency in dealing with that.
Then keeping that definition in mind, and the notion that you've just described, what would you think, because obviously you have a sort of a an experience in the public sector itself and how it works. So what would you say what you would like to see in terms of initiatives or changes in within the legal system or our justice system, if you were, so to say, at the top of the ladder?
Yeah, we often say that, there's no CEO of the justice system. And oh, if I were the CEO of the justice system, here's what I would do. Because, of course, the justice system is, as you no doubt know, very kind of siloed and often very kind of and not terribly accountable. One of the things I would do just on that point is try to make it much more accountable. So if we're going to deal with access to justice, we should have some accountability. We should have good information about what we do that is shared, and kind of realistic ideas and realistic transparency about what we are doing inside the justice system to deal with it. I would want people to actually move the justice system to a much more kind of user-centered, human-centered design. And by that I mean designing for the user, not the lawyers and judges and court workers who are in there, but to address the needs of the actual people that are there. It's a trite example that I give my students, but really, if you were doing this, if you were designing a justice system that did that, you would be having, court after hours, you'd be having daycare at court, you would be having all kinds of things that would be that we don't right now, right? And you would have and much more kind of facility for people to actually interact with the system in different ways. So those are some of the things, and I think, I guess the other thing that I feel challenged by and have historically felt challenged, certainly felt this when I was in government, is that there's a real lack of recognition and appreciation for access to justice issues, at the level of the public. And then that translates into, if the public is not really understanding that, then they're not going to demand or vote for people that actually want to make change inside the system, right? There's a sense that there's a sort of common sense, I think, that, if you're in the justice system, you're in there because you've made either a poor choice or you've done something antisocial. And therefore, why should we spend a lot of time and money on you? What is not well recognized is how many social problems originate as justice sector problems, and how many justice sector problems originate as social problems, and how the intersection of that, if we actually dealt with it and spent some money, dealing with these issues as broader kind of social issues, including how the justice sector addresses them, we would deal with them much more effectively. The sort of absence of a good kind of educated public on this is, I think, one of the problems with access to justice.
Yeah, well, based on that, I think, I've been to court a couple of times, just parking violations, but when I've been to court, I feel like when people are called to court to get a ticket or get a violation or whatnot, they come to interact with this strange actor of the government that we absolutely know nothing about, and the very building that you have to go in, you have absolutely no idea where everything is, and you're always guided to places. And when you get to actually the court, where you're supposed to hear the judge and whatnot, you're met with this extremely isolating system, if I want to call it that, because the judge is all the way up on the pedestal, and you have no idea what's going on here. And I think in a certain way, and I dare to say, it's designed to be a little intimidating for the people that go in, that especially don't know the justice system or the judiciary. Would you agree with that statement?
Absolutely. Yeah, historically, it is designed, and to the extent that one could say it was designed at all intentionally, it was designed to be intimidating, right? And I think that was the mentality at the time, is that there's this kind of reverence. It partly comes out of, I suppose, to some extent, an ecclesiastical background in the deep history of it, but there was this kind of reverence for the system that one had to have. but think of your experience, Nick. So you've gone in there with a parking ticket. If you were in there with a serious family law issue, and something around 80% of people now go in with family law issues go into court unrepresented because they can't afford legal services. If you were going in with all of the kind of drama and horrible, issues that were going on in a family law situation, so already you're deeply stressed, and now you're confronted with a system that you don't understand and can't navigate. Think of how awful that experience is. And is that the right way? Is that the right place to try to resolve family law issues? Just as an example. Another kind of interesting twist on that design, though, is the Civil Resolution Tribunal in BC, which has jurisdiction over some small claims cases and some other kinds of disputes in BC, and it's done entirely online, and you can access it 24/7, and have your dispute, be guided through a dispute. And so, there are issues with that too, because not everybody has access to technology, so they've had to kind of deal with that. But there are kind of initiatives out there to question and to look at how we might resolve disputes in alternative ways, and in ways that are proportional to what's involved. Because frankly, you probably shouldn't have to go to court for your parking ticket, right? There should be some other, and there are, in some jurisdictions, there are bots that now deal with parking tickets. But so that there is thinking on this, but there's a lot more to be done.
Of course, yeah. Well, certainly there are certain areas of law where I think legal advocates would agree that the judiciary is not completely necessary to resolve the issues that come up within these areas of law. And using that as a segue into our next question, let me refer to my notes here. How would you advise aspiring legal advocates, right? Because that's, after all, this is an undergraduate legal journal. So we're talking to a population that are either undergoing their undergraduate degree or already within the law as law students. So how would you advise aspiring legal advocates to work as contributors to the legal community, and to invoke access to justice while they excel or succeed within the area that they choose to practice in?
I love this question because it's a question that I ask my students. And in fact, just my last class, the day before I came here today, I asked this very question. And that's and how I pose it is that in Ontario, and not many other jurisdictions in Canada, but in Ontario, when you're called to the bar, the oath that you take when you're called to the bar includes making a commitment to seek access to justice and legal services. So you swear or affirm that among the many other things you will do that. So then I say to my students, so if you were called in Ontario, how would you make that work? How would you operationalize that? And it provokes a really generative discussion, because many of them have ideas, but then they realize that the realities for most of them in terms of practice, particularly in the early life of practice, is that they're going to be working hard, trying to make a living or meet billable hours targets, and where is there room and space in that world to kind of take on access to justice issues. But I think, and so we talk about that. If we talk about access to justice in holistic terms, in terms of that very broad, expansive definition that I mentioned at the outset, and in terms of enhancing well-being, I think, though, there's a lot that law students and young lawyers can actually think about. And it is partly getting beyond the win-lose mentality and treating law as more of a helping profession, like approaching your client from a whole person, whole problem perspective. That the client's bringing you a problem to be solved, not necessarily one that they want to take to court or have litigated. And how do we solve the problem? We have to recognize its full dimension. It's not just about rights and remedies. It's often, this goes back to your question on intersectionality and some of the other things we talked about. Often problems have origins in difficult power dynamics, economic issues, financial hardship, personal issues, mental and physical health, and family relationship dynamics. And these are all related, and we need to think about that when the client brings us a problem and what this problem needs. And that's probably invites more than just a legal solution, although a legal solution is part of that. And so that involves our need to probably work with other disciplines and other service providers in actually addressing the client's needs. And as I said, then adopting more of a helping profession mentality and ethic of empathy and care. And that doesn't necessarily mean that's something you can do now. It's not necessarily something that is taught from a skills or kind of foundational thinking perspective in most law schools, or at least not emphasized in most law schools. We do still tend to, I think, focus on substantive law and litigation. But frankly, when you get out of law school and into practice, the substantive law is only a very small component of what you're going to be doing on a day-to-day basis. And a lot of it is relational. And as I said, a lot of access to justice practice is empathy and care, both client and for the problem. That's not to say that there aren't very specific things. A whole number of students, talk about doing pro bono work and how satisfying, many of them have already done it, how satisfying they found that, working in legal clinics. And there's certainly a role for advocating for public education around access to justice and advocacy around access to justice that a lawyer can take on at any time.
I would like to borrow from what you said in regards to the oath that you take when you're called into the bar. Certainly, there is an emphasis on access to justice and the public interest when you call into the bar and when you take the oath. But then, as you established, when you start your legal career, when you go into the practice of law you choose to be in, life sort of gets in the way, right? Then it's billables, and then there's obviously you need money to pay student loans and whatnot. And we know that public interest law and legal aid or public defendant, they're not as lucrative as private practice might be. So within your expertise as a regulator of the legal profession or acting, on behalf of it, what change would you like to foment or see in the regulation of the legal profession that encourages the commitment to access to justice and public interest that lawyers do take when they're called into the bar?
Yeah, I mean, you've identified a real problem, Nicolas, in terms of the economies of access to justice, if I can take that, or a public interest law practice, right? And it is tough. It's not. It's harder for students these days with debt and the kind of commitments that they have to actually see themselves doing that work. I think legal regulators and law societies, at least some, I know ours locally in BC certainly is looking at this and saying, well, how do we make it easier for people to go into those practices? One way to do that is to make it less costly to transition into those practices. Do we need an articling year, for example? Are there alternatives to articling that would be less expensive and less time consuming? Can we make legal education more affordable? And I mean, there's no magic bullet here. There are, and then the other question is, can we look at different models of practice, that are shared practices, shared, back office kinds of work, practices with other professionals, practices in clinical settings. Not all of these are necessarily available now because of regulation, but can we be innovative in the way we practice law so that we can do it and serve the public and make a living at it, but actually increase the availability of support to people who need access to justice. And I mean, the other thing we have to look at, I think, is actually does everybody need a lawyer for every problem? Because there are, it's a bit of an anathema among lawyers, but there are ways in which, just a little bit of coaching or a little bit of information can go a long way to a person with an access to justice problem. How can we build models that support that.
Well, it goes back to the multidimensionality of the justice system itself, right? So if as citizens we know nothing about the justice system, then when we come to interact with it, we need somebody to guide us through it. So I think it goes back to what you said about education and sort of encouraging citizens to know more about the justice system that they're in, right?
That's right.
And well, when it comes to your career itself, and obviously you went the public sector and the access to justice, right? That was if I'm not mistaken, that was that was the latter part of your career, right? You started a private practice and whatnot. So specifically, when did you become passionate about access to justice itself? Like, was there a moment or a story or something that you noticed that made you realize that there was an issue that needed to be dealt with?
There wasn't one aha moment. I mean, I think it started for me as a young lawyer in private practice. In those days, legal aid was better funded, relatively better funded, and I did have legal aid files. And even then, it was tough. But as legal aid cuts were made, I began to wonder how the people that I had actually worked with in legal aid, particularly in family, as it turned out, we're getting through the system now because they didn't have that. The legal aid family stuff had by and large disappeared. So I was just kind of wondering. It wasn't burning at the time, but it kind of made me wonder. And then when I got into government and we started looking at, we started recognizing that there were issues with the way people dealt with their disputes and the fact that so many of them had to go to court and there weren't kind of other mandated processes or funded processes. And again, it just kind of started to churn for me. I think it became more concentrated. It's sort of what I've already said. When I got to the Law Society of Ontario and saw access to justice being focused on by the lawyers there, and started to work with people who were providing access to justice service. There's an amazing number of unsung heroes in clinics and legal information centers and those kinds of things, and started to work with people who were providing legal services in a wide variety of settings to a wide variety of populations, that I began to realize that this is a huge problem, and that there are wonderful people dealing with it, but we're not dealing with it effectively yet. And that's probably, there was a turning point. That's where it was. And certainly coming here and now studying it from an academic perspective, one realizes the breadth of the problem and the effects of it.
Oh, there certainly needs to be a sort of a focus that hasn't been there before. But sort of like switching up the focus in the questions, I wanted to sort of go towards our demographic in terms of the Canadian Law Review, so undergraduate students, law students. What sort of advice would you give these upcoming legal advocates as an experienced attorney in different areas of the law when it comes to stress and worries about the legal profession that it comes to? Because as we know right now, when we go in and become practicing attorneys, we've touched on some of the issues that we encounter. There's student loans, there's the viability of making a living through the legal profession, doing something that you're truly passionate about. What sort of advice would you give upcoming legal advocates when it comes to that?
That's a good question. There are probably 2 or 3 pieces of advice. In hindsight, this is not advice I would have taken myself probably at the time. But have courage to make change. Don't, I see too many lawyers, I think, just kind of making a living and very unhappy in what they're doing. And I always wonder, and I mean, it's easy, it's in one sense, it's easy to say, but, and not recognize their reality. But, if you're not happy doing what you do something different. The legal profession nowadays has a wide variety of opportunities, and one does not need to feel stuck where one is. Right? And so I just encourage people to think about what they want to do and to make change when it's not what they're passionate about anymore. There are, there's a wide variety of opportunity, and you'll be able to pay off your student loan. I mean, it's not like that's going to be the end of the world, or necessarily something that has to drive you into a certain type of practice area. So that's the one piece of advice that I think is really important. An unhappy lawyer is no good to anybody, really.
That's completely true. Well, that's actually all I got in terms of the interview questions and whatnot. So I've officially gone through my talking points. Is there anything else which you'd like to add to
No,
what we touched on?
I just commend you for your interest in this. And if anybody ever, I'm happy to talk to people at any time about this stuff. As you can tell, I'm pretty passionate about it.
Great, that's great. Yeah, I think there's a certain I think we should highlight, or there needs to be highlight the fact that a lot of advocates put very much a focus on mentoring opportunities, and this is a mentoring opportunity and a chance to speak on what you've been through and how your legal career came to be. So I think that's also worth commemorating.
Absolutely. Yeah.
All right, Leisha,